Property is a item that a person or a business has legal title over. Property can be tangible item such as houses, cars, appliances, etc. The property has to give some monetary benefit to the owner. Otherwise, it never be considered as a property. So, properties always they should have the feature of giving benefit to the owner of the property. There are some other assets which are intangible. These intangible property that can carry the promise of future worth. For example, that bonds, certificates, stock, etc. These intangible assets, they will give their benefit to the owner in the future. They don't have any physical shape. All these assets will be in the form of document only. There is another category of properties: fixed property, personal property, and our intellectual property. Fixed property, everybody know: buildings, lands, cars, appliances, all these will come under fixed property. These assets will give monetary benefit to the owner of the property. So among these assets, some assets will give monetary benefit and some other assets will give comfort to the owner of the property. And second category we have here, personal property. These personal properties, they have the movable feature. We can carry them anywhere along with us. The personal assets examples are our mobile, our watch, our gold ring, our gold chain, our cash in our pocket. All these are personal assets. We can take them away or we can carry them to anywhere. These are also will give some benefit to the owner of the property. Say for example, when we have a mobile, we can enjoy the benefit of making calls to any of our friends or relatives. In the same manner, if it is a smartphone, we can make several payments to the outsiders. In the same manner, we can receive the amounts also from our friends, relatives or outsiders. And thirdly, we have here intellectual property rights. These are intangible assets. They never have the feature of visibility. We cannot see them. The name itself indicates its meaning, intellectual property. Intellectual property means an individual's intelligence. It will come to the individual by birth. Nobody can take away, nobody can theft or steal these intellectual property rights from the person. The intellectual property right will be with the person till he dies. For example, when we have cash of rupees 500 or 1000 something else in our pocket, there is every chance to take away that money or there is every chance to lose that money in several ways. But when come to the intellectual property rights, there is no chance to take away the property by anybody. It is always with us. It is our intellectuality. It is our intelligence quality. So in intellectual property rights, we have several categories: patents, copyrights, trademarks, trade secrets, geographical indicators, computer designs. Like that we have so many intellectual property rights. In this particular session, I am going to explain you all now about intellectual property rights. This course, Intellectual Property Rights, introduces the students on the basics of patents, trademarks, copyrights, and trade secrets. Intellectual property rights and patents, there are some course objectives. The objective of this particular course IPR is to make the student understanding the subject, defining and differentiating the different intellectual properties and their roles in contributing organizational competitiveness. Understanding the framework of strategic intellectual property rights management. Understanding the framework of strategic management of intellectual property rights. Appreciating and appraising the different intellectual property management approaches. Another objective of this particular course is appreciating and appraising the intellectual property management approaches and also describing how the pioneer organization initiate, implement and manage intellectual property management programs. And finally, another important objective of this particular subject, intellectual property rights and patents, is understanding of real practice of intellectual property management. So these are the objectives of this particular course. For this particular course, intellectual property rights and patents, there are some outcomes. A student can learn many things about these intellectual property rights and patents. He will come out with a good knowledge on this particular subject after completing the course. Now we will see one by one what are the outcomes that a student can learn. After studying the particular course, a student can identify the different types of intellectual property rights such as patents, copyrights, trademarks, trade secrets, geographical indicators, etc. like that. He also know the ways to create and prepare trademarks and how to write books, novels and movie stories, lyrics and how to create new musical tunes and all. Such knowledge will come in the minds of the students by doing this course. A student can also recognize the crucial role of intellectual property rights in an organization for its development and prosperity. The students can also identify what are the activities pertaining to the intellectual property rights and what are the infringement activities to be done by the others without the knowledge of the owner or the creator of the particular intellectual property right. Here, in this particular intellectual property right, once the license is granted by the owner to any other person, such person only has the right to use that particular right. He should not transfer the license to any other person for doing misuse and doing infringement. When the owner knows about this, he has every right to file a case against the person to whom that intellectual property right is endorsed. The course also makes the students familiar with the process of the intellectual property management. By studying this course, a student can able to anticipate and subject to critical analysis pertaining to the development of the intellectual property management. And finally, by doing this course, students can also able to know the ownership rights on different intellectual property rights. When come to the introduction part of the subject intellectual property rights and patents. Intellectual property rights are the rights given to the persons over their creations and innovations, and also for their writings and the creation of new computer designs and any new musical tunes and all. The intellectual property rights will give the owner the exclusive rights. He has every right to sell his creation to any company or to any organization for monetary benefit, or if he is not interested to sell away that license on his intellectual property or on his creation, he can give his license for a company for a particular period to produce and sell the creation what he created. In the term intellectual property, it includes many types of intangible assets like patents, copyrights, trademarks, etc. All these assets, they don't have any visibility and they don't have any physical shape to see. They are all intangible assets. We can see them on the paper only or on the document. This particular intellectual property rights, they give protection to the owners and exclude the others interfering in the issues of intellectual property rights. The main types of or the forms of intellectual property rights are patents, copyrights, trademarks, trade secrets, geographical indicators, computer designs, etc. Here, for each and every intellectual property right, the protection, the way of protecting the right is different. For example, for patents, for its protection, there is a patent law. In the same manner, for trademarks, trademark law, and for copyrights, copyright law. Like that, each and every intellectual property right here, it is having a different, a specific or a special law or act for its protection. There are some inventions which may be covered by multiple types of intellectual property protection. It is important to consider a number of business and legal factors before selecting the best protection strategy. The origins of intellectual property. The history of intellectual property is complex and fascinating. It begins in 500 BCE when Sybaris, a Greek state, made it possible for citizens to obtain a one-year patent for any new refinement in luxury. Patent, trademark, and copyright laws have become more complicated in the ensuing centuries, but the intent remains the same. Countries establish intellectual property laws to foster creativity and to make it possible for the inventor to reap the benefits of their ingenuity. There are some rights pertaining to the intellectual property. I will now list out one by one. The first one we have here, it has a right on literary, artistic and scientific works. It also have rights on performances of performing artists, phonograms and broadcast, and inventions in all fields of human endeavor. These are also will come under the purview of intellectual property rights. Next, scientific discoveries, industrial designs. On these two, the intellectual property rights, they have rights. Trademarks, service marks, commercial names and designations. These are also will come under the head intellectual property rights. Intellectual property rights have a right on protection against unfair competition, and finally these intellectual property rights also have right on all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic fields. What is intellectual property law? Intellectual property law deals with the rules for securing and enforcing legal rights to inventions, designs, and artistic works. Just as the law protects ownership of personal property and real estate, here intellectual property law protects the exclusive control of intangible assets. The purpose of these intellectual property laws is to give an incentive for people to develop creative works that benefit society by ensuring they can profit from their works without fear of misappropriation by others. Intellectual property law basics. Patent law covers the legal conditions under which an invention may be patented. In India, patent law requires that the invention be of patentable subject matter and have utility, novelty, and non obviousness. A patent examiner judges patentability during an off trial examination of a patent application. If the patent is granted, the invention is presumed to have been patentable. However, if an error occurs during the granting procedure, infringement litigation may result. This may occur if, for example, the examiner failed to research all prior technology in the field of the invention to confirm that the invention had novelty. If the invention was not truly novel, other patent holders may bring legal action against the patent. Copyright law. A copyright gives the owner the exclusive right to reproduce, distribute, perform, display, or license his work. The owner also receives the exclusive right to produce or license derivatives of his work. Limited exceptions to this exclusivity exist for types of fair use, such as book reviews. To be covered by copyright, a work must be original and in a concrete medium of expression. Under current law, works are covered whether or not a copyright notice is attached and whether or not the work is registered. Trademark law. Trademark law is relevant in virtually all industries and is an area that represents tremendous growth and importance in today's economic climate. Trademarks are generally distinctive symbols, pictures, or words that sellers at risk to distinguish and identify the origin of their products. These marks are protected by federal laws that require registration with the federal or state government, giving the owner exclusive rights to use it on the product it was intended to identify and often on related products. Because companies invest tremendous resources to the development of the production of these rights from infringers, whether these rights are owned or licensed to others. Trademark law helps owners properly obtain, protect, and utilize an intellectual property portfolio for their business success. Types of intellectual property. Patent. A patent is used to prevent an invention from being created, sold, or used by another party without permission. Patents are the most common type of intellectual property rights that come to people's minds when they think of intellectual property rights protection. A patent owner has every right to commercialize his patent, including buying and selling the patent or granting license to the invention to any third party under the mutually agreed terms. Types of patents. There are three different categories that patent can fall under. Utility. A utility patent protects the creation of new or improved product, process, composition of matter, or machine that is useful. Design. A design patent protects the ornamental design on a useful item. Plant. A plant patent protects new kinds of plants produced by cuttings. Trademark. Trademarks are another familiar type of intellectual property rights protection. A trademark is distinctive a distinctive sign which allows consumers to easily identify the particular good or service that a company provides. Some examples include McDonald's Golden Arch, the Facebook logo, and so on. A trademark can come in the form of a text, a phrase, a symbol, sound, smell, or color scheme. Unlike patents, a trademark can protect a set of class of products or services instead of just one product or process. Copyright. Copyright does not protect ideas, rather, it only covers tangible forms of creations and original work. For example, art, music, architectural drawings, or even software codes. The copyright owner has the exclusive right to sell, publish, and reproduce any literary, musical, dramatic, artistic, or architectural work created by the author. Trade secret. Trade secrets are the secrets of a business. They are proprietary systems, formulas, strategies, or other information that is confidential and is not meant for unauthorized commercial use by others. This is a critical form of protection that can help business to gain a competitive advantage. Geographical indicators. Geographical indicators and appellations of origin are signs used on goods that have a specific geographical origin and possess qualities, a reputation, or characteristics that are essentially attributable to that place of origin. Most commonly, a geographical indication includes the name of the place of origin of the goods. And finally, industrial designs. An industrial design constitutes the ornamental or aesthetic aspect of an article. A design may consist of three-dimensional features such as the shape or surface of an article or of two-dimensional features such as patterns, lines, or color. Finally, the overall idea or the overall objective of this subject is to impart the knowledge in the minds of the students about various types of intellectual property rights and their usage and their advantage. Here we know already the intellectual property rights are patents, copyrights, trademarks, trade secrets, etc. So all these intellectual property rights, how they will give their benefit to the students or how the students get benefited by using all these intellectual property rights. This particular subject, it is mainly important for the engineering students for new startups and innovations. Nowadays, many students are doing the course engineering. They are doing the engineering course just like doing normal degree course. An engineering student has to do the course by keeping some ideas in their mind for creating new things and making some innovations or adding his knowledge to the existing technology. There are several ways for proving himself as an engineer by using the intellectual property rights in several ways. Doing simply for the sake of getting an engineering degree, it is a mere waste. Nowadays, many engineering students, they are going for getting the jobs in the software sector. In fact, that is not correct. There are several branches pertaining to the engineering course. Electrical and electronics engineering is there. Electrical and communication engineering is there. Mechanical engineering course is there. Similarly, civil engineering course is there. Among all, there are some conventional branches. That means with these branches only the course engineering has come into existence. That branches are civil, electrical, mechanical, chemical, engineering, etc. So these are all the conventional branches. My advice to the students pertaining to these branches, conventional branches, unnecessarily don't go for getting a job in the software field, which is purely for computer engineering students. You have several ways to prove yourself in your core engineering field. So kindly go for getting the job in your core field and to try to innovate and to try to create new things for the development of the industrial sector and ultimately for the development of the country. I hope you all understood well. Thank you.